Hello, welcome to the Zaller Law webinar. I'm Anthony Zaller. This webinar was recorded in November of 2024 at our live event. It was called the Zaller Law Employer Summit that took place at the Castaway Restaurant in Burbank. We'll be doing a lot more of these in-person events going into 2025, probably on a quarterly basis. So if you're interested in attending any of those, please let us know. We'd be happy to send you an invitation. So with that said, we'll jump right into the live recording. If you've got any questions after you watch the webinar, feel free to reach out to any of the attorneys here at Zaller Law. We'd be happy to answer any questions. And happy holidays, everybody. Put together a couple of slides last night on what the Trump administration is going to impact, how that's going to impact California employers as well. The short of that is not a whole lot because California is so progressive already. No matter what Trump does on the federal level, we've already surpassed that. So, but there are a few benefits, as the last panel was talking about on the union aspect. I see that playing some role here in California as well. So we'll get into that. And then we'll just do a quick reminder about 2024. We had a few big developments, so a few reminders for the clients in the room. You've heard about this already, but we'll just touch on those quickly and get through that. And then we're off to have some drinks over at the restaurant. So I always stand in between the drinks and everything. So we'll make it fast and get through this. And as I mentioned, we'll make these slides available. We have a lot of content here. We're going to move pretty quickly, but we will make it available for everybody. So jumping into the new employment laws for 2025, I think Pooja is going to start us off here.
Yes, great. Thank you, Anthony. So starting on January 1st, employers who complete a voluntary non-governmental social compliance audit that's in whole or in part to determine if child labor is involved in the employer's operations or practices will be required to publicly share those results. So first, what is a social compliance audit? Well, it's a voluntary non-governmental inspection or assessment of the employer's operations or practices to evaluate whether those operations are in compliance with state and federal labor laws, including wage and hour and health and safety regulations, including those regarding child labor. So it's important to remember this isn't creating a new obligation to employers to complete this audit. It is that if an employer chooses to complete this audit, then they need to follow these very specific reporting requirements. So what is that requirement? The employer must post a clear and conspicuous link on their website that goes to a report that includes all of this information. So it would include the year, month, day, and time that the audit was completed, whether that audit was completed during the day shift or the night shift, whether the employer did or did not engage in or support the use of child labor, a copy of any written policies and procedures the employer has regarding child employees, whether the employer exposed children to any workplace situations that were hazardous or unsafe to their physical or mental health and development, whether children worked within or outside regular school hours or during night hours. And finally, a statement that the auditing company is not a governmental agency and is not authorized to verify compliance with state and federal labor laws. So I will turn it over to Anne.
Thank you, Pooja. So there are two new poster updates that are going to be in effect January 1st. And the first one relates to a whistleblower posting update. The current law requires employers to post a list of employees' rights and responsibilities under the California whistleblower laws. While the California Labor Commissioner actually has posted a notice, the notice also says, oh, but we're not sure that this is 100% compliant. So this new law requires the Labor Commissioner to actually develop and post a model list and notice that will comply. So this is my takeaway from this new law is this is an easy one to follow. The poster will be available on the Labor Commissioner's website. And we've got the link right there as well. There is also another posting requirement of workers' compensation. We've got the slide a bit out of order here, and when it pops up, you'll see that, but there's very specific requirements now. So this is a good time to plan for your poster requirements for 2025, whether you have the individual posters or those all-in-one posters. Easy compliance dealing with the posters. A little difficult with some of the more complex regulations that we have. So the next new bill that will also come in effect January 1st is the Senate Bill 399, and that's called the California Worker Freedom from Employer Intimidation Act. And this new law essentially will ban all employer-mandated meetings where the employer is going to be expressing an opinion about politics or religion. And encompassed within this is talking about union activity. So you cannot require employers to attend these meetings. You're not supposed to take any adverse action against someone who declines to participate in the meeting as well. And also, the new bill will prohibit dissemination or any other type of communication on the political or religious opinions of the employer. So there was some talk, I think Juan Carlos had mentioned that. So this is something new. There are, in fact, several other states that have passed similar laws. So,
on this, if I could jump in quickly too, I just wrote an article about this with Elon Musk being very activist and supporting some employees to sue Disney. There was an actress, Gina Carano, that was an actress for the Mandalorian show. She expressed some conservative views on Twitter. Disney fired her. And under California law, there's already protections in place that says an employer can't discriminate against an employee for their expressing their political views and what they do off work conduct. And the legislature passed this, I think, to protect employees from conservative viewpoint, but I could see some of these activists that are out there like Elon Musk using this to flip the story on that. And I'm going to be talking about it under the Trump administration as well. The DEI agenda is under attack in some states, and I could see this law being used as an activist to try to shut down that kind of communication with employees, even though it's supporting a progressive agenda. But it does not say like only one agenda is permitted in the workplace. So we'll keep an eye on this carefully, and I see this being a battleground next year.
There are penalties associated with this new law, and a private employee can bring a civil action, and the labor commissioner can also bring a civil action. I think many people are of the opinion that this new law is going to be challenged in the courts from a variety of reasons, least of which is a constitutional right to free speech, and also preemption under the Federal Natural Labor Relations Act. So we're going to keep an eye out on that. And of course, there's a ban on requiring the attendance, but there's no ban on having the meetings. So if an employer wants to express his opinions or educate the workforce about union activities and campaigning, you can do that. You cannot mandate and require. If someone doesn't want to attend, you're going to have to pay them their time to do that, and of course not taking adverse action against that employee for the failure to attend.
So another bill that is going into effect on January 1st is AB 2499. So what AB 2499 does, it expands the protection of employees who are victims of violence or who have family members who are victims of violence. So currently, the law is that employers may not discriminate or retaliate against employees who are victims of violence or who have family members who are victims of violence. What this bill does is it expands the definition of a victim to include any qualifying act of violence. So this includes things such as domestic violence, sexual assault, and stalking. The bill also expands the reason for taking time off, and this can include medical attention, obtaining services, psychological counseling, mental health services, or safety planning. The bill also requires this leave to run concurrently with any leave under the federal FMLA or the California Family Rights Leave Act leave. And employers must also provide a reasonable accommodation for employees who are a victim or have a family member who's a victim of a qualifying act of violence to ensure their safety in the workplace. This bill also will expand paid sick leave for an employee to take time off under this bill, so they could use their paid sick leave to take time off. And finally, employers now have an affirmative obligation to provide notice to employees of these rights at the time of hire annually, anytime an employee asks, and as well as when an employee informs the employer that the employee or the employee's family is a victim. I'll turn it over to Yaron.
Good afternoon, everyone. I will pick up the discrimination train. Clearly, that discrimination was on the top of mind for California legislature because we've got several different Senate bills that were enacted and put through to become effective January 1 of 2025 that touch on discrimination. And when we talk about discrimination, we're talking about both discrimination and retaliation and the related. So SB 1100. This has to do with the driver's license. So by way of background, and you may not know, but California Fair Employment and Housing Act prohibits various forms of discrimination in both employment and housing. And it's protecting against various characteristics, not the least of which is national origin. So in 2013, California Department of Motor Vehicles was authorized to issue driver's license to undocumented immigrants who provided proof of their identities in California residency. So that was in 2013. The following year, the Fair Employment and Housing Act was amended to make it a violation for an employer to discriminate against individuals with these types of driver's licenses, so specifically those that were issued to undocumented immigrants. As explained by the legislative history for SB 1100, the driver's license is irrelevant to most jobs. And requiring a driver's license disproportionately impacts people with disabilities, low-income individuals, those living in urban areas with access to public transportation who choose not to drive or own a vehicle. And so based on that, SB 1100 was born. So what it does is it adds to the list of prohibitions under the Fair Employment and Housing Act and makes it an unlawful practice for an employer to include a statement in a job advertisement, posting, application, or other material that an applicant must have a driver's license. You can include that requirement that the applicant have a driver's license if you satisfy two requirements. One, that the employer reasonably expects driving to be one of the job functions for the position. And two, that the employer reasonably believes that satisfying the job function using an alternative form of transportation would not be comparable in travel time or cost to the employer. So by way of example, though, if you may be asking yourself, well, what is an alternative form of transportation? The new legislation was helpful enough to provide an example and a definition for that term. And so what we understand it to mean is that it includes, but is not limited to, using a ride-hailing service, using a taxi, carpooling, bicycling, and walking. Okay, so we'll continue with the discrimination agenda, and let's talk about SB 1340. So this bill specifies that nothing in the California Fair Employment and Housing Act limits or restricts efforts by any city, county, or other political subdivision of the state to enforce local anti-discrimination laws, so long as it satisfies 4 requirements. Those 4 requirements are that the local enforcement concerns an employment complaint filed with the Civil Rights Department, CRD. 2, the local enforcement occurs after the CRD has issued a right to sue notice. 3, the local enforcement commences before the expiration of the time to file a civil action specified in that right to sue notice. And then lastly, the local enforcement is pursuant to a local law that is at least as protective as the Fair Employment and Housing Act. So this is a situation where it can't be more expansive, but if it's more restrictive than the current applicable law, then it's okay. So the law requires a CRD to promulgate regulations governing local enforcement pursuant to these provisions, and we'll see how that works out. We'll keep an eye on, keep you posted with latest developments. But ultimately, local agencies now can play a more active role in handling discrimination complaints, potentially providing quicker and more localized responses, while opening employers up, unfortunately, to a patchwork of discrimination laws at the local level. Let's take a look at the next discrimination-related legislation. This one is SB 1137. SB 1137 brings in now to our vocabulary a term called intersectional identities. Intersectional identities is where 2 or more characteristics result in a unique form of discrimination. So under FEHA, currently, and provisions of the Education Code as well, all persons are entitled to full and equal accommodations regardless of their sex, race, color, religion, so forth and so on, and there's a litany of protected characteristics. Existing law defines these protected characteristics as including the perception that someone has any particular type of characteristic, among other things. What SB 1137 does is it clarifies that these laws prohibit discrimination not just based on one protected characteristic, but based on the combination of 2 or more protected characteristics. That's where we have this intersectional identities term now to note. So the author of this bill, California State Senator Lola Smallwood Cuevas, she noted that discrimination transcends singular dimensions, and so this bill is intended to be common sense reform that addresses the intersectionality of discrimination cases, providing greater protection for Californians, especially those from our most marginalized communities of color. And the example that's given is that an Asian female employee could experience workplace discrimination based on her race or gender, but also the combination of the 2, which subjects her to a set of stereotypes and assumptions not shared by her coworkers who are not Asian, or by her Asian coworkers who are not male.
So if that sounds confusing, it is. This type of, I don't know what this law is trying to do. This discrimination was already illegal, and it's adding another layer of complexity, which the bill does very little to explain what it's trying to do.
You're absolutely correct. And really what this is, and that's why, when you can see it's at the top of the legislation in mind when they're touching on these various bills to expand discrimination, or in this instance, intend to clarify. But really what this is it comes on the heels of various court decisions and the plaintiff's bar, trying to avoid, when they're put to task on what the alleged discrimination is and what the protected characteristic is, so employers and defense attorneys have been attempting to combat those by focusing on the very particular characteristic with a variety of evidence. And when you do that, it can put the plaintiff in a box. And what this is intending to do is, regardless of what you think, you can't put the plaintiff in a particular box of one characteristic. And it could be a combination, and there's this gradation. So it's not like binary anymore. It's not black or white, but shades of gray. And on your end, for California employers, that there's nothing for you to do different. Discrimination is already prohibited. This is really more something for the plaintiffs, for the attorneys to play around with in court when and if a litigation begins. Okay, so let's continue with the next. This is AB 1815. This bill expands the definition of race in the anti-discrimination provisions under the law in California. So under the amendment, the term historically was removed from the definition of race, and it is now inclusive of traits associated with race as opposed to inclusive of traits historically associated with race, including but not limited to hair texture and protected hairstyles. Protected hairstyles now was clarified to include hairstyles such as braids, locks, and twists. And there's not much else to it. This is more a slight expansion and a clarification of the definition. It was still prohibited. All right, so let's move on to the next one. This is AB 2123. This concerns disability compensation, paid family leave. So under the existing law establishes for provisions of wage replacement benefits to workers who take time off work to care for certain serious ill family members, to bond with a minor child within 1 year of birth or placement, or to participate in a qualifying exigency related to the covered active duty or call to covered active duty for certain family members. And this was under the state's disability insurance program, SDI, as you may know it on wage statements. Existing law authorizes that employers can require employees to take up to 2 weeks of earned but unused vacation before and as a condition of receiving these paid leave benefits. Effective January 1, 2025, that authorization for employers to require that 2 weeks for vacation be used first is no longer applicable. And what that means is now employers can no longer require employees to use accrued vacation before accessing eligible paid family leave benefits. The next slide talks about workers' compensation and notice, and I'll just touch on this quick because Ann had touched that there was 2 posted notice changes for 2025. This is the second. Ann referred to that slide that was out of order. That's this. And it very simple. It just adds, there used to be 9 categories that were required on the notice. This adds a 10th. That 10th category is that to notify employees that the injured employee may consult a licensed attorney to advise them of their rights under workers' compensation laws. In most instances, attorney's fees will be paid from an injured employee's recovery. I just read that to you. That's literally the language that's going to be included on the notice. You don't have to worry if you get a code-compliant notice that's updated for 2025. That should be there. And that's it. And with that, I will turn it over to Anthony.
Yeah, I kind of wanted to have all of us chime in on this too, if you have any other thoughts. But just to look forward, that does that for the major legal update, what we covered. So as you can see, as I mentioned, nothing major. Some minor policies need to be updated in the handbooks for some of the victim protected leave, but nothing major. So we got through relatively scot-free. So, yep. So just looking forward, obviously we've got January 1st coming up. We've got the minimum wage bumping up. Currently, it's going up to $16.50 per hour. It looks like Proposition 32 is going to fail. I just checked that before we came here. It is trailing, but surprisingly, California is only like 53% of the vote counted so far. So there's still a lot of votes to count. It could change, but it looks like it's going to fail. Just a note on that too, to go back to the prior panel about some of the social media advertising. This Proposition 32, there was only $1.8 million spent by both the proponents and opponents of that bill, which is really small in terms of propositions in California. It was the least amount of money spent on any proposition on the ballot right now. What everybody's going to now are text messages and social media and podcasts. I just thought that was an interesting issue. Normally, these minimum wage bills raise a huge amount of money from businesses on one side and unions and proponents for the employee on the other side. So it played out a little different this year. Surprising to me that it failed. I don't know. I thought it was going to pass. But it is a little surprising. But with the FAST Act going up to $20 per hour, I think the consumers are seeing this is impacting their pocketbook too, and we can only push the minimum wage up so high, and that's the impact here. And as I've got here, AB 1228, the Fast Food Act is in place. We're at $20 per hour for the fast food operators. The council met back in September. The minimum wage for the fast food industry will be going up January 1st. The council's supposed to tell us, but we don't have word yet what that's going to increase to. So I'm getting a lot of statistics, and actually, Juan Carlos, I'd like to talk to you about this during drinks too. The state is publishing a lot of stats saying AB 1228 has not cost any jobs. And I just saw yesterday another group coming out saying, no, contrary to that, it's cost a ton of jobs. And I can see the state setting up the argument like, we can keep increasing this $20 per hour. There was no impact on jobs. Let's just keep increasing it and everybody will be fine. And I see that messaging coming out from the state. Yeah. Yep. And what I'm hearing too from operators, it's not necessarily you're letting people go, but you're just being very careful on the amount of hours. And we've talked to a lot of clients on this. So yes, they still might have a job, but instead of working a full 40 hours, it might be 32 hours a week now, or it might be 15 hours a week. And yes, it might have been nice to have an extra person on just in case the rush came through or the catering order came through. But now the employer's saying, nope, go home. It's too expensive. And if we get a catering call, we'll call you. So that's what we're seeing as well. So I don't know those stats. We'll see how that plays out, but it'd be good to talk. I'd like to talk to you guys about that during drinks. And then May 14th, we've got the California pay data reports are due for employers with 100 or more employees. This is a California obligation. So California employers have to do these reports and start working on those at the beginning of the year, gathering that data. You have to classify employees based on their job title and their ethnicity and the amount of pay. So start looking at that, and I'll be talking about what the Trump administration is going to do on the EEOC level, likely getting rid of the federal reporting requirement later in the year. So I'll talk about that here in a bit. But for California employers, we still have this California obligation that will come May 14th. July 1st, then we're looking at all the local city and counties. Most city and counties are increasing their minimum wage July 1st. We do have a few cities and counties coming up with the increase January 1st, City of San Diego and West Hollywood, but for the most part, the majority are later on July 1st. That basically does that. So getting to what the Trump administration means, that's a mean picture of Trump there. But that was the only one I could get that was royalty free, and I didn't violate anybody's copyrights. That's his official picture he took for running. So I was like, I guess I'll use that one. So immigration, as you all know, he's tough on immigration. So we expect to see that increased enforcement and workplace investigations and to crack down on that. And, with the deportation, does that mean he starts looking at workplaces as well that are employing undocumented workers? I think it's likely. We'll have to keep an eye on that to see how that plays out. As I mentioned, the EEOC pay data reporting, we do have the EEO1 component. They still have to report that, but it was component 2 that came up during the Obama administration where the employers had to report payroll data with the other ethnicity data. Now, payroll data has not been required to, employers have not been required to report that since 2018, and the Biden administration was looking to re-implement that next year, but under the Trump administration, I expect that to go away. But you'll still have the component 1 reporting, but it's a lot easier and you don't have to get into the wages and pay for the employees. As I mentioned, the DEI initiatives, uncertain impact on California employers. I've got some stats here under that point. Some Republican attorneys general came out and said, hey, these Fortune 100 companies, if you're enforcing these DEI policies, it violates state law and federal law, we're going to come after you. And then we had 21 Democrat attorney generals say the contrary, like keep doing it. We support your efforts on the DEI. So it's a patchwork right now. And then I put up there 15 states, including California, have the pay transparency laws. So just wanted to put that out there and share that. So we'll see how that plays out. I think it's going to be an issue going forward. Labor relations with the unions, definitely Trump pulled back on the ability for unions to unionize and pursue employees, and I think he'll continue that. He'll name a new people to the the NLRB, and pull back on that quite a bit. So that's something to watch. But interesting, though, I was reading last night, J.D. Vance did propose a bill as a senator to let the employees, and I haven't read the bill, I was running out of time getting ready for today, but it was something like letting the employees basically unionize on their own and talk to their employer without the union being there. So privatizing unionization. It was interesting, and coming from J.D. Vance, something up there, and the fact that Trump had the union representatives speaking at the national the conference. Yeah, the conference. It's interesting to see where that goes, and who supported Trump too. It's the blue collar workers, non-college educated workers. So this is really kind of Trump's voting base too. So it's going to be interesting to see how it plays out. The federal minimum salary requirements under FLSA, I don't want to get into it a whole lot. It doesn't impact California employers. Outside of the state, it's going to impact you, and it gets a little tricky. It's set to go up January 1st, but here in California, we're under a much higher standard. We're under the, I've got the standard here. The $68,640 per year on an annual basis to qualify as an exempt employee. So on the federal level, they're trying to bump their levels up too. But it doesn't really pertain to anybody here in California. And then tips, the big issue is no tax on tips. We'll see how that plays out once the administration gets in as well. The Republicans have proposed a bill, no tax on tips, preserving the tip credit for states that do allow for the tip credit. Obviously, here in California, we do not have a tip credit, so that won't really impact us here. And then the Democrats have also proposed a bill that proposes no tax on tips, but they try to eliminate the tip credit. So we'll, and obviously, I think Trump will go with the Republican bill or some variation of that, but we'll keep an eye on that going forward. Really quickly, some cases to watch here in 2025. We've been watching this case for over a year, I think. We were talking about this last year this time, the Home Depot case in front of the California Supreme Court about time rounding. Prior to this case, employers were permitted to round time if it went both ways for the employee. So if they came in a bit early, it would round up, but if they came in late, it would round back. So as neutral rounding policies were permitted under a See's Candy case. The California Supreme Court's taking another look at this, and this is the only case I've got a prediction on, and they're going to come out and say employers can't use rounding policies in California. They've already come out in the the meal break context for the 30-minute meal break in the Donahue case, saying you cannot round time for that 30-minute meal break, and I expect them to carry that over in this case. So we're keeping an eye on that. If you're rounding, our recommendation to clients is stop doing it. Just go to actual timekeeping. Don't round. It's trouble. You already have trouble with differentiating your meal break, having a different policy for that with regular time. So just stay away from that. The Fuentes case is getting into arbitration agreements. And here we had an employer that required employees to enter into an arbitration agreement. We're getting into some weeds, and I won't get into the details, but a few issues that I wanted to point out. Arbitration agreements are key to use here in California. You could have a class action waiver built into the arbitration agreement, and this is enforceable, and employers should have that. What we've been trying to do is build a PAGA waiver into that as well so that the employees waive their right to bring a PAGA claim. The California Supreme Court has shot down that argument. So at least we can get a class action waiver in arbitration agreements. It's worth it. A lot longer statute of limitations and additional penalties accrue with the class action. So just get the class action waiver. We're still going to have to defend the PAGA claim, and we'll talk about that here in a little bit. But I'd still rather just be defending a PAGA claim as opposed to a class action and the PAGA case. And arbitration agreements, employers can mandate them under current law, but our advice is make them voluntary. When you roll them out to your workforce, just a handful of people are going to refuse to sign it. And it makes it easier for us to enforce those arbitration agreements when we go to court, when it's saying, hey, look, it's a voluntary agreement. And if you have a handful of your employees opting out, it's not going to be big enough to create a class action or a major PAGA liability. So we recommend making those voluntary.
Can you hear me? Oh,
Yeah.
okay. I just wanted to touch on one point. In the hospitality space, that's what Anthony said is spot on. If you're in the transportation space, trucking international, doing interstate, and subject to the hours of service regulations and whatnot, the voluntary nature of the arbitration agreement is absolutely critical because the Federal Arbitration Act does not apply to you. You cannot get the benefit of that. Motor carriers are exempt from the Federal Arbitration Act. So when we're talking about mandating or making an arbitration agreement a condition of employment and requiring employees to sign, well, technically you could do if you were not a motor carrier or in the transportation space with interstate trucking. If you are, then absolutely you have to have a voluntary arbitration agreement.
Good point. Good point. And that's our advice across the board, though, is to make it voluntary. Our form agreement, if anybody, I think most of you probably have it already, is voluntary. That's where we go. But if anybody's interested in having a mandatory one, you could talk to us about it. We could help. This case, Hohenschelt, again, dealing with arbitration agreements. Here, California, there's a strict timing requirement when you're in arbitration. When the arbitrator sends the bill to you or your attorney to start the arbitration, it needs to be paid in a timely basis, 30 days. If it's not paid, the employee can then say, okay, arbitration's done, we're back in the court. So this case is dealing with that issue. If it's late, is there some excuse to get around that? And does federal law preempt the state law that requires this timing issue? But again, it's just a good example. The plaintiffs don't like being in arbitration, and they do everything they can to get out of arbitration. And we as the employer generally like to be in arbitration and do everything we can to get to arbitration and stay in arbitration. And then this case, Ilioff, some issues here. I won't get into the details, but there's some good faith defenses to avoid liquidated damages for labor code violations, and they're getting to the standard on what qualifies for a good faith defense and whether a plaintiff has a private right of action to sue under the state paid sick leave laws. That's still an issue. So that'll be interesting. We'll keep an eye on that. But it's really just for the lawyers to keep an eye on. And then finally, this delegation and foreign selection clause case, Zhang, this was actually involving an attorney working for a big New York law firm, had an agreement with the law firm. The law firm said, as an employee in California, you're going to delegate these claims. We're going to have them heard under New York law. And I forget in this case if there was a choice of venue as well. We're going to have the case heard in New York. California has a labor code section 925 that prohibits employers from implementing choice of law and choice of venue provisions in agreements generally. So this is one issue that's testing that, and we'll see, we're watching that. But it's just a good reminder for employers. If you're using severance agreements, you can actually put a choice of law or choice of venue clause in there. Under this law, it's still permitted, but be very careful when you're hiring employees. You can't have these agreements with employees that we're going to apply some other state law if they're here in California, working in California. So keep that in mind. PAGA reform 2024. This is not getting a lot of news. A lot of our clients have heard from us, but this is huge development in favor of the employers in 2024. We had this reform come through in June, and I won't get into the details of PAGA. We'll treat this as the honors employment law class here. So if any questions about it, feel free to talk to us about it. But any employer of any size, as Juan Carlos said, is kind of a target now for these PAGA cases. We've seen cases down to 30 employees. They got this PAGA exposure, and the liability adds up huge. I've got a slide on that here as well. So we've been watching the number of these PAGA letters filed with the LWDAs, and this is a prerequisite. The plaintiff's lawyer has to file this letter with the state agency before they file a PAGA lawsuit. So we've just been watching those. It's public record, and as you can see, it's been ticking up consistently. Here in 2024, already in October, we're close to what we were in 2023. I expect the number of PAGA letters to exceed that. So they're still increasing, even with this reform that went through. The plaintiff's bar is kind of putting the blinders on and continuing with the PAGA cases. So it's still important to be as compliant as possible. And this reform built in additional provisions that you can do if you can show a good faith effort to comply with the labor code, caps the penalties as low as 30 or 15% of what they could get under the original PAGA. The kicker is, though, if they can show you willfully violated the labor code, the penalties increase. So every plaintiff's counsel is going to be arguing you as an employer violated the labor code and you intentionally did it to try to get those old penalties that they had before the reform or to get these increased penalties. Here's a stat. This chart is just showing the number of PAGA letters filed by month. We had this weird blip here in June when the plaintiff's bar heard that there was going to be reform coming through. All of a sudden, we saw them all file PAGA letters to try to get in before the reform. And fortunately, the law addressed that. They couldn't sneak any PAGA cases in before the reform was actually announced. So we saw that weird anomaly. But as you can see, they dropped off in July, but they're starting to tick back up to normal levels that we saw before the reform. So it's still an issue for California employers. On this slide, it shows the types of reductions that we can get. So a case with just a number of employees at 100 employees and looking at a normal statute of limitations pay period over 2 years, a plaintiff's counsel can easily argue under PAGA, the original PAGA, you're at $2.3 million when they could stack these penalties. And they would claim, well, because you didn't provide a meal or rest break, therefore, you also didn't provide an adequate wage statement because your wage statements were wrong because you didn't provide the meal or rest break. They would stack all these penalties up and it would get to these huge amounts. And this was hard to negotiate against because they would start at a high number and we'd start at 0 and start negotiating. Now, under the reformed PAGA, if we can show this cap of 15%, if we're taking reasonable measures to comply with the labor code, it's going to cap the penalties at 15%. It can get them down to, the example I have here is $156,000, a 93% reduction. And I'd rather start When the plaintiff's counsel is arguing this number to start at in negotiating, it's much easier to negotiate a reasonable settlement and get it resolved early. The reform has also built in some other protections for employers that encourages the parties to try to settle these cases early too. So large employers, if you have more than 100 employees, you can actually petition the court once the PAGA case is filed to stay the entire case and say we're going off to mediation. Even if the case doesn't settle at mediation, you can go back to the judge, tell the judge, we want you to settle this case for us. We've made good faith offers to settle. Let's get this thing settled. And it's a huge tool employers can use to try to get those attorney's fees cut off from the plaintiff and get it resolved early. So I'm going over this really quick. This is not our PAGA reform seminar, but it's just something I wanted to flag for everybody. We do have resources on this, so if you've got any questions, let us know. We can share that with you. But here's what shows the good faith, reasonable steps to comply with the labor code. And I've got a lot of slides on this, and as I mentioned, I'll make the slides available. But as usual, you need to look at the meal and rest breaks, pay policies, make sure everybody's on the clock. You've got good complaint procedures in place. You're looking at the pay records too. If the employee's not clocking out for the 30-minute meal break or full 30-minute meal break, you're following up with the employee. Why weren't they clocking out? And taking steps to alleviate those issues. We also are seeing this reimbursement for all work-related expenses. A heads up on this, we see a lot of timekeeping systems going to cell phones, using the employee's cell phones to clock in and out. There's arguably a good argument that the employer then has to reimburse the employee for the use of their cell phone for clocking in and out. So as we're using to this digital workforce and we're communicating more with the employees on their cell phones, keep that in mind. I'll get through this quickly. So this Donahue case that I mentioned earlier, one issue was the rounding. You can't round for the 30-minute meal break, for tracking the 30-minute meal break. The other issue here was saying if the employer used an attestation with the employees where the employee didn't take their 30-minute meal break and they signed an attestation saying, yeah, I voluntarily waived that. I was able to take it, but I didn't want to take it. It shifts the burden to the employee in litigation to prove otherwise then. Huge tool for employers to be using. If you don't have some form of attestation, you should look into that and develop something. It does not have to be electronic. You can give them a piece of paper, have them sign it. We don't generally like them signing it when they get the check. The argument is, I felt I had to sign that and acknowledge that to get my paycheck. So I like to do it on weeks different than the paychecks. So it just takes that argument. 9 times out of 10, 99% of the time, we see that in a deposition. You signed all these attestations. The plaintiff says, I felt I was required to sign it to get my paycheck. So that's a good way around that. But another tool for employers to use. Cool. So we'll get through this. Update handbooks, obviously. Train supervisors on this, a big component. And I would use your time training the supervisors during sexual harassment prevention training, add another 15, 20, 30 minutes to that training to go over these wage and hour laws, explain timing of meal and rest breaks, what's required for them in that training, and then document that as well. And then take appropriate actions, discipline managers who you find violating the policy, document that. That's going to be huge. And also too, I have clients that get nervous about when the employees miss their meal break and you have to pay an extra hour of pay for the premium pay. They want to hide this issue. You're like, oh, this is bad. Somebody messed up. Alternatively, we try to really highlight those issues. If you know it got busy and the employees weren't able to take a 30-minute meal break, document it. Pay them the extra premium pay, document that. And then when you get a lawsuit saying you had this policy that people were forced not to take their meal breaks, you can go back and point to these records saying, no, to the contrary, when we knew they had to work through the 30-minute meal break, we paid them the extra hour of pay and documented it. And here's all the instances where that happened. And that's going to be a huge defense I think it's a defense to show zero liability, but at the minimum, you're going to be able to prove you were at least in good faith compliance to get this 15% cap on the penalties. And then again, we still like arbitration agreements with class action waivers, even though we can't waive PAGA. Great. So with that, looking back on 2024, just quickly, we'll get through this really quick.
If I can, real quick, talking about PAGA and liability and bring in the concept of EPLI insurance that Mitch had mentioned. It's a very good point. I mean, our record, is employment practices liability insurance right for every employer? It's really, you have to assess so many factors, and we always recommend that you talk with your broker about that. Keep your, go in with your eyes wide open, whether you've got it already and you're up for renewal or you don't have it and you're considering it. There's just so many factors to consider. Don't be surprised. A lot of times employers won't find out till after they've been sued that the policy doesn't cover wage and hour or PAGA lawsuits, that it only covers, or it's limited and capped at certain thresholds, $100,000, and that's all they'll pay, and they'll only pay defense fees and not pay for a settlement or anything else. So you want to know your coverage, do your homework, don't be surprised. Insurance companies are extremely sophisticated. Some alternatives to EPLI coverage is possibly think of setting up your own fund, self-insured, so to speak, rather than paying premiums every month. Set it aside, and of course, be compliant. All the HR, good HR practices that we advocate and educate about all the time. That's going to be part and part of the whole package.
Yep, good point. The other issue too with the EPLI to negotiate up front is choice of counsel. If you've got a lawyer you work with, negotiate that up front. Once you get sued, a lot of insurance companies will send you to their panel counsel, and it's somebody that doesn't know your industry, has never worked with you, doesn't know your policies, and maybe, new to the industry. Something else to think about on that, and do that. Yaron, could you really quickly touch on the indoor heat illness law? And I know we're out of time, but
sure, I'll make it real quick, and you'll get the slide. But the bottom line is that we've got effective mid-year of July 24 of 2024, indoor heat illness prevention regulations went into effect. Cal OSHA has these regulations. It applies to most indoor workspaces, restaurants, warehouses, manufacturing facilities, where the temperature reaches 82 degrees or higher when employees are there. So if that applies, if you've got space, restaurants, you're looking at your kitchen by way of example, then what you need to do is provide access to clean drinking water, provide access to cool down areas, provide cool down rest periods. These are like additional rest breaks. Provide assessment and control measures, whether it's engineering controls, administrative controls, or personal type of protective equipment, all designed to help keep workers safe from heat illness. Monitor the weather or the temperature in the space if needed, have an emergency response plan and communicate that plan. Observe new workers. So we got a new term, acclimatization. So in this instance, what it means, it's that 14-day period when you're introducing a new employee or a current employee to a new area or workspace where they're going to be near radiant heat source or a source where it's 82 degrees or higher. At that point, you need to closely monitor for that acclimatization period the employee to observe any signs of heat illness and symptoms. You need to make sure that they're okay. Recommendation is that you are proactive and you are encouraging frequent breaks, water. Make sure that you want to be preemptive in this. Once you see signs of heat and illness, it's not too late, but it's already gone far. Now you're dealing with closely monitoring, putting them in a cool down area and watching them. So before that happens, you want to make sure that they have adequate drinking water and you are taking measures to keep them cool on a regular basis before they're exhibiting those signs. And then train your employees. That's not just line level employees, that's supervisors as well on this. And you want to establish a written heat illness prevention plan. Fortunately, Cal OSHA has a model plan available for employers, a template, if you will. It's got everything there. You just need to make it specific to your site, your workspace, and your employees. So it does need modification, but all the tools are there and it's available. And certainly, if you need help, we can help.
Yep. And then I won't cover it, but we'll make the slides available. The food handler card, just a reminder on the costs for that. And as well as the violence protection prevention plans, employers are obligated to implement and roll out. So if you haven't done that yet, it's something you have to get on ASAP. So just a reminder on that. Great. And that does it for our content today. I'd really like to thank the team, Pooja, Ann, and Yaron for helping put the slides together, as well as Katie, Lizette, and Jeremy helping put everything together today. And with that said, let's go have a few drinks. Thank you, everybody.